Please, Your Lordship.
Morning.
I have hearing item number 5. Since today there's some cases are fixed for today, this may be taken up on Wednesday.
Item 5 of
5 of hearing list.
hearing list.
Yes,
Okay, Wednesday.
Wednesday. Okay.
Yes.
Seek Lordship's indulgence in respect of part 2, item 12 and 14.
Yes.
Matters could be taken up on Thursday. I'm for the appellant in both the cases.
Item number
12 and 14.
12 and 14.
My lord.
13 on 14 or 12 and 14?
12 and
is,
14.
12 is an RFA.
My lord.
You want it on Thursday.
If possible.
All right.
And 14 is a criminal appeal.
14 is, I think, okay. All
It's
right.
a PC Act, my lord.
All right.
It's a very short matter.
All right.
Deeply obliged.
Yes. Call the list.
For motion, item number 1.
This is that revision matter.
Yes, my lord.
CPC. Which is the order under challenge? Review was dismissed.
Yes, my lord.
This is parties are represented.
Yes, my lord.
Sole respondent.
Yes, my lord.
Yes, where is the impugned order?
Review order is next to the index.
Review was filed by the respondent in the heirship certificate.
Yes, my lord.
Heirship certificate granted was dismissed, correct?
Yes, my lord.
And then a review was filed.
Review was filed by the petitioner itself.
Who is the petitioner? The plaintiff.
During the time of heirship certificate, we are the plaintiff.
You applied for heirship.
Yes, ma'am.
Then the heirship was granted.
Yes, ma'am.
And then
And then after that, it was review application was filed by the.
and that
petitioner.
review was dismissed.
Yes, ma'am.
Against that they have come for a
Yes,
revision.
ma'am.
Yes, you had all the opportunity.
Yes, my lord.
I don't see any merit in your review.
Because my lord, as on
Read paragraph 4.
my lord, this review in before the review petition airship in airship
Ma'am, kindly come to the impugned judgment and read paragraph 3 and 4. It's just four paragraph judgment. You see, review is not a matter of right. You have to make out a case of review. It is settled principle of law that the error must be apparent on the face of it. Only then a review can be made, not for a rehearing or some. Review is not a rehearing, right? Or it is not because you did not have some document and you want to bring it. This is not the purpose of review. Now you kindly see para 3 and 4 of the judgment. Please read it.
that the 2 floors of the state family building
Please read paragraph 3 of the impugned judgment, ma'am. Index Roman 2.
okay. That the petitioner humbly seeks indulgence intervention of this honorable court through
Please,
this
please.
instant civil revision petition for setting. Sorry. On the other hand, the learned counsel for the respondent submitted that the heirship certificate number 2230 of 2019 was supplied on the basis of settlement between the surviving sons of Van Huaytanga, wherein father of the petitioner number 2 was alive and had consented to the application. Thus submitted, there is no error apparent on the face of the record while issuing the imprint order. Number 4, the main contention of the petitioner is that they were not given opportunity of being heard while the respondent had applied for the imprint order and heirship certificate number 2230 of 2019. However, the respondent is the sole surviving son of Van Huaytanga and thus is the only direct legal heir of the deceased. Although opportunity of being heard were to be given to the petitioners, as prayed for, they are not entitled to the grandfather's property as Chapter 8 Inheritance of Fathers, Head of Family Property under the Mizo Marriage, Divorce, Inheritance of Property Act 2014. Thus, it is held that there is no discovery of new and important matter or evidence, nor mistake or error apparent on the face of the record, nor any sufficient reasons to review the order dated 28/11/2019 and heirship number so and so. Hence, the petitioners are not entitled to the review as prayed for.
So the heirship initially was granted without any notice.
Yes, my lord.
And who are you?
I am the grandson of the deceased Van Huaytanga.
Grandson.
Yes.
Now, under the Mizo Marriage, Divorce and Inheritance of Property Act, the court has taken a note that the grandson has no right. Is that correct position of law?
Yes, my lord.
Then,
Sir, your lord. However, before this 2230 of 2019, before this heirship certificate was issued to the respondent had previously applied for heirship certificate, and objection was filed by the petitioners. And then, however, the heirship number 570 of 2017 was dismissed by the senior civil judge 1. As on page number.
what is the error apparent, ma'am? What is the error apparent? Please point out the error that is apparent.
Yes, my lord, that the previous heirship 740 was dismissed by the senior because, as on page number 12, my lord. May I read?
Page number?
12.
Yes.
As the issues that would be arising cannot be properly and effectively settled in any application only, the case is hereby dismissed with liberty to all the parties to approach appropriate court in appropriate manner.
How is it relevant? The grandson, the appellant had filed it.
Yes.
And it was disposed of. This was a heirship certificate you had applied for. That was dismissed.
Yes.
Yes.
And in this order, it's mentioned that it cannot be settled in application only.
With liberty.
Yes. And yes, it was dismissed. And after it was dismissed on November 22nd on the same year, the respondent again applied for another heirship.
That was granted.
Yes, without issuing any notice to the.
But you are admittedly the grandson.
Yes.
Where is your right under the Mizo Inheritance, Marriage, Divorce, Inheritance of Property Act? Show me that you have a right. If you have a right, notice has to go. If you don't have a right, where is your right to be heard?
Yes.
Because
yes,
you
my
have
lord,
to appreciate that you are before a very limited jurisdiction, right? You had filed a review application. You are aware of the parameters of review? When can an order of the court be reviewed? What are the grounds?
reviewed for the grounds is that no application was issued, and also, my lord,
Grounds
yes, in
of review, ma'am. You have filed for a review. You should know what are the grounds of review. Don't convert the courtrooms into some college. You must be aware you have come seeking review. challenging the dismissal of the review order. Under what provision of CPC review? Are you carrying a CPC? Why? This matter has come for motion. You're not even carrying the relevant book. The court is asking you about the parameters of review. You seem to be not knowing. This is not the manner you will be assisting the bench. I'll take up this matter tomorrow. Do your homework properly. Tomorrow.
For admission, item number 2.
Please, Your Lordship.
Yes.
The issue herein is
Oh, this is that matter. Where is your junior? She vanished today. Huh? And yes.
ready to hear the matter.
The substantial question, I think, is something, some remand for de novo.
Yes.
That is the substantial question, right?
Yes, madam.
Where is it? Which page? Yes, page 25. Yes, what is substantial?
Now, my lord, I'll take your lordship to order 41. Rule 23.
1 second. Order?
Order 41, Rule 23.
Yes. There it is in two components.
Yes.
One is by framing a preliminary issue and sending it back, and the other is that the court otherwise also has a power of remanding.
Now, in our
What are
case,
they? Yes.
the trial court has decreed the suit in our favor,
Yes.
not on a preliminary point, but based on the pleadings and the evidence of the parties. Now, the learned First Appellate Court has remanded the case back for de novo trial without invoking any of the provisions contained in CPC. Now, here, remand is very limited under CPC. Your Lordship will see Order 41, Rule 23.
Yes.
I'll read this with your
Yes,
Lordship
please.
permission.
Yes, please.
Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point, and the decree is
So the
reversed in appeal.
suit was disposed upon a preliminary point.
Not on a preliminary point.
Not on a preliminary.
Not on a preliminary point.
Okay, please read.
And the decree is reversed in appeal. The appellate court may, if it is fit, by order remand the case and may further direct what issue or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, with direction to readmit the suit under its original number in the Register of Civil Suits, and proceed to determine the suit and the evidence, if any, recorded during the original trial, shall, subject to all just exceptions, be evidence during the trial after remand. Now, I'll take your lordship to Rule 23A, remand in other cases.
Yes.
Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary
So
point
in your case, it has been disposed of
on merit.
on merit.
On merit.
So otherwise then on a preliminary point.
Yes. Now,
And the decree is
it's
reversed.
reversed in
in
appeal, and if retrial is considered necessary, the appellate court shall have the same
So
power.
this is what has been done, I think, in your case.
No order or section has been invoked by the
That
London
need
Appellate
not
Court.
be. You see,
Yes, correct.
non-mentioning of the section will not make
Yeah,
the
I
unless
agree.
you can trace the power.
I agree, I
The
agree.
power is there, 23A.
Yeah.
Correct.
I agree.
Now,
Now,
just 1 second, Mr. Lalfagwala.
I'll come.
Where is? I just wanted to check. Order 40. FAO is order
Order 41.
or FAO
FAO, Order 43.
43. Kindly come to your appeal is under what?
Section 100.
Kindly come to order 43 rule U.
Order 43.
Should it be an appeal from orders? Kindly
Or-
see.
An order under Rule 23 or Rule 22 of Order 41 remanding a case where an appeal would lie from the decree of the appellate court.
Because you are against the remand order.
I am against the remand order.
So should it be an order under, should this appeal be under order 43 rule U? Just examine this because
No,
I
my
can
lord.
take it up day after tomorrow.
I have another this rule, Rule 24 of Order 41. Rule 41, Rule 24 of Order 41.
Rule?
Order 41, Rule 24.
Rule 24.
Rule 24.
Yes.
Where evidence on record sufficient, the appellate court may determine case finally.
That is different.
No,
Here the appellate court has not exercised its jurisdiction under Rule 24. Correct?
No.
It appears because the order is a remand order. De
But-
novo in trial.
Correct.
Correct. So it appears that the jurisdiction exercise is under 23A. Now, if it is under 23A, then the court provides an appeal under Order 43,
Yeah.
Rule 1U.
That's correct. If your lordship may kindly see the impugned order, page 41.
See, in both situations, nothing changes. Only thing the registration can be converted.
Yes.
But let us be clear, because I don't want at the later stage this defects to unnecessarily vitiate the proceeding, isn't it?
I
So
agree.
we must be clear under which provision of the CPC the appeal has to be maintainable.
I agree. Now, if your lordship will kindly see page 41 of the impugned order.
Page 40.
Page 41.
Yes.
Para 11.
Yes.
With the above reasons and finding, the instant appeal is allowed to the extent that the impugned judgment and order dated 18/10/2021, along with decree dated 18/10/2021, passed by the Land Senior Civil Judge for Azol District, Azol in Civil Suit number 111 of 2011, is hereby set aside and was due to non-consideration of counterclaim preferred by appellants defendant number 1 and number 2. The suit is sent back for de novo trial from the stage of settlement of issues in relation to the counterclaim made by the appellants defendant number 1 and number 2. Now, in our case, the defendant has filed a counterclaim. Now, there are initially 17 issues were framed. Now, the learned trial court, which has passed the impugned judgment, has framed 3 issues, which covers the instant case. Now, in our case, the decree was not reversed in favor of the defendant counterclaimant or the appellant in apex court. First appellate court. Now, in this case, what Rule 23 says is that when the suit was not disposed on a preliminary point and the decree is reversed. Now, in our case, the decree was never reversed in favor of the defendant or the appellant before the first appellate court. The learned first appellate court has enough evidence to pronounce judgment
Pronounced judgment.
because their pleadings were
Because
complete.
remand has to be sparingly done. Correct.
Yes, and to that effect, I have a judgment of the Honorable Supreme Court, which
So
I'll
you
place
mean
before.
to say there are procedural irregularity, and that is why the substantial
Yes,
question arises?
yes, correct. Now, my prayer here is now, let the first appellate court decide the issue on merit.
Where is the substantial question? Yes.
Now, Your Lordship will kindly
Ajari's case is well known.
page 496. The relevant portion is para 32, 33, and 34.
Para,
32,
page
page 496.
496.
Yes, in 2008 8 SCC 485 case.
No. I'm talking about your case. That is all right.
All right.
In your case.
That's substantial question.
Yes.
I'm sorry. Page 25.
Yes. Whether the first appellate court ordered no and remanding the case. And this, in this, you said page 400?
In this 2008 8 SCC 485,
Yes.
page 496.
496?
Yes. Para 32, 33, and 34 are the relevant paragraphs. I will read from para 32 with Your Lordship permission.
Yes, please.
A distinction must be borne in mind between diverse powers of the appellate court to pass an order of remand. The scope of remand in terms of Order 41 Rule 23 is extremely limited. The suit was not decided on a preliminary issue. Order 41 Rule 23 was therefore not available. On what basis the secondary evidence was allowed to be led is not clear. The High Court did not set aside the orders refusing to adduce secondary evidence. Para 33, Order 41 Rule 23 A of the Court of Civil Procedure is also not attracted.
All right.
Maluk.
All right. Should this question we will then frame A and B, but is A, should we change the question or should we remain? I think little change probably is required in that question.
We'll just mention the order, Maluk.
I think.
Yes.
So you recast these two questions
Maluk.
and we will recast it and give it to the court master.
Maluk.
Mary. Heard Mr. C. Lalfaxwala, learned counsel for the appellant. Stop. Also heard MS.
It's actually being handled by PH1 for me, and she's on maternity leave.
You are the state respondent.
Yes,
All right. Give your whose name? Give your name. MS.
Lalun Louis,
So and so for
state respondent number 3 to 7.
3 and
3 to 7.
3 to 7. Appeal stands admitted on the following substantial question of law 1 and 2. Recast it and give it to me. I will check and I will put it. And after that, you say notice returnable 4 weeks. MS. Yes, your name.
Lalun Louis,
So and so accepts notice on behalf of respondent number
3 to 7.
3 to
7.
3 to 7. No formal notice, extra copies within the course of the day. Who are the other respondents?
Private respondent 1 and 2. Now, yes.
Notice for steps in respect of respondent number 1 and 2 by registered post agent within a period of 3 days from today.
Maluk, if I may,
Appeal under section 100 of CPC 1908 against interim judgment and order dated 7/9/2023 passed by Additional District Judge 1 Aizol in RFA number 11 of 2011 arising out of civil suit number 111 of 2011. It's in the course title page 1 in case you need. Yes, Mr. Lalfaxwala, you were saying something?
yes, Maluk, in respect of respondent number 1 and 2, we have served them notice.
I have seen, but you see, they have not
They have not appeared.
correct. Now, since I'm admitting it, I'm issuing it again. So you take steps.
I'll take steps.
First of all, I do not understand the concept of issuing notice on the first day in the second appeal, because second appeal, if substantial question arises, that has to be framed, admitted, and then notice. Perhaps that should be the procedure, isn't it?
Yes.
Why these matters are unnecessarily dragged? Because respondent will come, at the time of hearing, they have a right to show that the matter doesn't involve a substantial question of law.
We'll serve notice.
All right. Please give that recast.
Yes.
Yes.
Item number 3.
Miss Mary is there.
My lord, I am.
Mary, I was looking for you the other day because, see, at the time of editing the order, I need to be completely sure that the order of this court has been complied, right?
Yes.
Now,
Yes.
if I have understood it correctly,
Yes.
from the instructions that you had handed over, it talks about 3 settlement certificates.
Yes.
First one is 42 of 1980, second
Yes.
is 43 of 78, and the third is 93 of 86. Am I
Yes.
correct?
Correct. Correct.
Now, if you see that report, as far as 42 of 1980 is concerned, it
Yes.
does not say that this land does not belong to the petitioner. Am I correct?
Yes, my lord.
Then when you come to 43, it says the land does not belong to petitioner. So no problem. As far as 43 is concerned, nothing remains to be done because this land is not the petitioner's land. Correct?
Yes.
Now when you come to 93, again for 93, there is nothing saying that this land does not belong to the petitioner. Correct? Now if you see paragraph 6, it says it is respectfully submitted that in view of the observation of the site, the verification team as mentioned above, the claim made by the petitioner in view of 43 and 93 are highly suspect and cannot be entered in after lapse of many years. For claim regarding 42, the so-and-so visited, got her consent and signature for a document stating that she consented to the widening of the road. However, this document cannot be located at this stage. This I am not finding it very satisfactory, Ms. Mary, because it appears that the land belongs to the petitioner as far as 42 and 93 are concerned.
My lord, it is an admitted fact that the land belongs to the petitioner. There is no dispute in that.
See, right now we are only at a stage where we are concerned whether the order of these courts have been implied or not implied, complied or not complied. Now, if there is some difficulty for you to comply with the court's order, you have all the remedies open for you, correct? You could have come by way of a miscellaneous application. You could have gone for appeal. Those are available in law. But sitting silent, not doing, that is absolutely cannot be tolerated by this court, isn't it? Now, the manner in which the report is submitted before the court also is not inspiring confidence. I think I will give you a chance. You have maybe you file an additional affidavit clearing the whole stand, because you see the order is in 3 parts. Now, if we go to the order, which is at page 13, what according to you are the direction in the order, Ms. Mary?
Yes, the direction is that if there
Number
is
1, go by one. According to you, what are the directions that has to be done?
first verification team has to be instituted, that is done, and then on receipt of the certified copy of the order, the verification team consisting of the persons concerned have to verify the construction of public, whether road is constructed in the land of the petitioner. Now I have submitted before your lordship that It is not a disputed fact that the land do not belongs to the petitioner. It is a fact, admitted fact, that the land belongs to the petitioner
In
and then
respect
there
of
is one
two,
more land.
in respect of two settlements.
In respect of two settlements, the one settlement was mentioned because it was also on the way. It was adjoining land, and they have to verify the site, and then if they want to permanently acquire the said portion of land, if in affirmative, state shall make requisition for acquisition of land as per law. That is the first one. If they want to acquire.
Otherwise, compensation.
Yes. Second is that otherwise, on verification, if there is a damage, they should assess that damage caused.
See, Miss Mary, I am on this. Suppose it is a fact that the petitioner's land is being used. They are saying that probably she has consented to the widening. They are not being able to trace that document as far as 43 is concerned, and as far as 92, they are saying there is no documents. So then it appears that something more has to be done. You cannot stop the matter here and saying there is no document showing that she has consented. All right, she may have consented, she may not have consented. But the fact of the matter is that as far as the land settlement to 43 is concerned, she is the owner. It is her land. And in that case, you either compensate her or you stop utilizing. You must do something.
Correct. But my lord, if I may, we have
So,
to
Ms.
be very
Mariti,
clear.
this code is not an execution code. So I am not
Yes.
going into all that. I am just giving you an idea what is going on in the mind of the court. As far as the
Yes.
contempt case is concerned, I am not satisfied. I feel that something more has to be done. So, and I've expressed it to you. So what I will do is I will give you a chance. You have a word with your officers, and if required, you do more, whatever is to be done, you do it, and you file an additional affidavit clearing your stand. My
Okay.
dear. Because
Yes.
otherwise it doesn't look good. Because that day, I had this impression that the petitioner's land is not occupied. But when I was going through, I saw...
My lord, it is an admitted fact that there was a road existing.
Correct.
And then from the verification report also, it is stated that no area is encroached for the construction of the metal paved road. And this was done in the year 2011.
Maybe,
That is way
maybe,
back in more than
maybe.
20 decades.
See, maybe, but it is the petitioner's land is involved, isn't it?
Correct.
So-
But then
so
there
if
is
the
an admitted
petitioner's
fact
land
that
is
no
involved,
area
Ms.
is
Mary,
encroached.
the right to
Yeah.
property is a basic human right that cannot
But
be
my
deprived
lord, as
without
per the
giving
joint
any
verification-
compensation or acquiring.
Correct,
Anyway,
correct,
I
my
am not
lord.
on that. I am not on the validity of these orders. I am not the executing court. I am only concerned whether the orders of this court is complied or not complied. As
The only
of
fact
now,
that-
it prima facie appears it is that there is something more to be done. That is why I'm giving you an opportunity to bring up, to file an additional evidence and affidavit and clarify your stand. And you think over it. If something is to be done, you get it done. That's all, isn't it? We are all concerned about the orders of the court. Nothing more, nothing less.
Nothing more, nothing less.
Yes.
But then that is why I'm saying that no area is encroached upon the
Very well, you
construction.
clarify your stand then. Yes, right. Heard MS Valentina so-and-so, learned counsel for the petitioner, stop. Also heard MS Mary, learned counsel for respondent numbers 10, 12, for respondent numbers 10, 12 and 14, 15, Miss Mary.
No, my lord. 1 to 4,
1 to 4.
1 to 4, 9 to 11, 14 and 15.
1 to 4, 9 to
9 to 11.
9 to
9
11,
to 12. Sorry, 9 to 12.
9 to 12
14.
and 14, 15.
Yes.
Perusal of the show cause reply affidavit filed by the respondent number 11 on 6/8/2024 appears that a verification team was constituted in terms of this court's order dated 17/8/2022 passed in WPC 128 of 2021, non-compliance of which is the subject matter in the present contempt petition. Stop. It further appears that pursuant to the verification, comma, a report was submitted whereunder on scrutiny of the subject lend passes, the following observations were made. A to A at page 4 of the affidavit. Page 4 to page 6. Green highlight, and I've marked A. Perusal of the aforesaid averments indicates that the petitioner is the owner of the land, petitioner is the holder of the land settlement certificate number 42 of 1980 and land settlement certificate number 93 of 1986, comma, against which it appears that though it is reported that the said land is used in connection with the subject road construction, comma, however, it is reported that the petitioner in respect of LSC number 42 of 1980 had consented to the widening of the road. However, the said document is not available in the office of the respondent at this stage. Stop. It is further reported against LSC number 93 of 1986 that the claim made by the petitioner appears to be highly suspect. Stop. As regards 42,
My lord, if I may, my land is number 42 of 1980 and 43 of 1978, not 93, my lord.
93 is not your land.
Not mine, my lord.
It's not your.
Not mine.
Okay, then you say on reported that delete the other part and simply say that perusal of the above appears that the verification team, after conducting the verification, has observed that the claim made by the petitioner in view of GLSC number 43 of 1978 and GLSC number 93 of 1986 are highly suspect and cannot be entertained after lapse of many years. Stop. This, no, sorry. Pursuant to the aforesaid inquiry, the respondent stopped thereafter and has not done anything else as directed by this court in WPC 128 of 21 by order dated 17/8/2022. Stop. It appears that this court clearly directed that pursuant to the report of the verification, comma, if it is found that the land of the petitioner has been used by the respondent numbers 3 and 4 for construction of a public road, comma, the state respondent shall take necessary steps for acquisition of the subject land as per law, and in the event the state respondents are not willing to acquire the land of the petitioner, comma, the respondent number 3 and 4 shall stop using the petitioner's land and shall verify and assess the damage caused to the petitioner's land. Stop. As it appears that the verification report is not clear as regards the claim of the petitioner, comma, the respondent has not taken the further steps, be that as it may, and at this stage, MS Mary seeks 2 weeks' time to clarify the stand in the matter.
My lord, if you're not audible sometimes, I cannot hear properly.
Sorry?
I cannot hear the dictation properly, my lord. Sometimes you're audible, sometimes you're not audible.
There's some trouble in the hearing. To file a detailed affidavit clarifying the stand of the respondents. Stop. List this matter after 2 weeks is sufficient to clarify your stand?
My lord, 3 weeks
3
considering
weeks. All
my
right. 3
situation.
weeks. List after 3 weeks on a date to be fixed by the registrar.
I'm deeply obliged.
Simply you clarify the stand properly.
Definitely, definitely.
Item number 4.
My lord,
This is a 173 Motor Vehicles Act.
yes, my lord.
Why this appeal is not admitted? Yes, you are the sole respondent.
No, my lord. For respondent number 2 only.
My
I'll
lord,
admit it.
my lord, the reason is that respondent number 1 is not appeared before this court.
That's all right. He'll appear later. Have you made the statutory deposits?
Yes, my lord.
Where is the note about the statutory deposit? I can't find it here.
My lord, in check, I had given to the.
Just check. If the deposits are made, I will admit it and call the next matter in the meantime. Please find out.
Item number 5.
May I please your lordship, this is regarding the suspension of the village council within the
What about
district council.
service respondents?
Your service respondent 1 to 7 is complete.
1 to
7.
how many respondents?
Dusty.
How many respondents?
Respondent lordship 7.
7 respondents. Dusty service you have filed.
Yes, we have filed the affidavit.
Nobody has appeared.
Yes, nobody has. I have a talk over phone that the chief executive member that they will appoint the standing council later.
Then we'll have it fixed after a week. In item 5, heard Mr.
A.K. Roku.
A.K. Rokhum, learned counsel for the petitioner. Stop. None appears for the respondent number 127, despite the service having been completed. Stop. List this matter again after 1 week. After 1 week on a date to be fixed by the registry. You inform them.
Obliged, lordship.
Item number 6.
My lord, this item number 6 and 7 are clubbed together. And yesterday I was not well. I'm still a little bit under the weather. So if the matter may be passed over just for the day, my lord.
Mr. Lalram Tenga, have you
Yes.
filed your response?
Yes, already, my lord. We have
Response-
already filed.
Everything is
Yes.
are complete?
Yes, complete.
Yes, my lord.
Which
So
is the court's order? Which is the court's order?
my lord, I'll come to that.
State respondent to take a decision as to whether the land acquisition proceeding should be initiated and completed in terms of LA Act so and so.
Yes, my lord.
The decision is taken or not taken?
Decision has been taken. They had even issued a preliminary notification for acquisition of my land. Now the issue that arose here was that as per the Land Acquisition Act, what happened was that my land was initially notified for acquisition in 2012. Now, for certain reasons, it was later on withdrawn, but nevertheless, it was subsequently taken over by the government. As such, we approached this honorable court and filed the writ petition. Now, this honorable court's direction was that if the lands of the petitioners were actually occupied and construction of road was done, then you pay the compensation as per the prevailing law. Now, at that point of time, we had the 2016 Mizoram Land Acquisition Act, which was in force at that point of time. Now, in a separate case, just for the day, my lord, just for the day. Take it up tomorrow.
Yeah, I have no objection, my lord.
When?
Tomorrow?
Tomorrow, if possible.
Day after.
Day after.
Wait for list. Yeah.
Deeply obliged.
Much obliged.
Item number 8.
Please, Your Lordship, in this case is a contempt matter. And this honorable court has issued notice to respondent number 3. And we are directed to take step as dusty service also. And we have filed affidavit regarding we have a service upon the respondent number 3, dusty service.
What about the other respondent?
The other in the order dated 1/8, it is written here in paragraph 4, Mr. Such and such learned counsel for the petitioner submits that at this stage, notice may be issued to the respondent number 3 only, and subject to the reply submitted by the respondent number 3, notice may be issued to the other respondents. That's why we have issued on.
All right. So R3 is complete.
Yes, it's complete. I have filed the service report by affidavit.
You have served it.
I have served.
Who is R3?
R3 is the
Principal.
Chief Conservator of Forests.
It can also be served by the resident.
Yes. And we can wait for just a short time.
Yes, yes. He himself has accepted.
Yes.
Or it's taken. MS?
Dinari.
So and so Leonard Counsel for the petitioner draws the attention of this court to the affidavit of service filed on 12/8/2024, wherein the acknowledgement dated 9/8/2024 is enclosed to show from which it is evident that the respondent number 3 has received the notice. Accordingly, service in respect of R3 stands complete. List this matter after 2 weeks on a date to be fixed by the registry.
Item number 4.
You have a copy.
Yes, my lord, I do have an office copy
No?
that I have submitted.
Mr. Murmu, you are appearing for whom?
Respondent number 2.
Respondent number?
True.
I will admit this appeal. It's a territory appeal. Heard Mr.
Isak Ramdinthara.
Counsel for the petitioner. Also heard Mr. R. Murmu, learned counsel for respondent number 2.
Yes.
This is an appeal. This appeal is preferred under section 173 MB Act 1988 against the impugned judgment and award dated 2/2/2024 in MACT case number 53 of 2015. Stop. It appears that the statutory deposit has already been submitted before the registrar of the Aizawl bench. Stop. Let the appeal be admitted. Let the case records be called from the that you say. Issue notice, returnable 4 weeks. Mr. R. Murmur, Learned Counsel, accepts notice on behalf of R2. No formal notice. Extra copies within the course within a period of 3 days from today. Steps by registered post against R1. Okay, within a period of 3 days from today. Let the case records be called from the court of from the MACT. Which one? MACT Aizawl district. List after 4 weeks on a date to be fixed at the registry.
For orders. Item number 9.
Where is Miss Linda?
My lord, Miss Linda is on legs in another court. She has hearing matters and she has requested me to adjourn this matter for Wednesday.
Or
To list this matter on Wednesday.
Wednesday?
Yes, my
Why
lord.
Wednesday? What is so special on Wednesday? Why not tomorrow? Is she prepared or not?
Yes, my lord, she's prepared, but she
Shall
has
we have it
hearing.
tomorrow?
Yes, if possible tomorrow, my lord, because the co-accused has already been
Yes,
released,
that's right. That's why. Tomorrow.
my lord.
List again.
Item number 10.
And the request of
11.
My Lord, in this matter, I am led by my senior, Mr. A.R. Malhotra. He's on legs in court number 1. So if I may
You
be,
are good enough.
if I may be accommodated for the day, my Lord.
You are good enough. I'm sure you're competent to object to 1,896 days of delay.
In fact, my Lord,
Ah.
as per the last court's order, my Lord, the registry was directed to verify the number of days delayed, my Lord, because as per my calculation, the days
No, the registry has already verified and given a report.
my Lord, I have not
Therefore,
checked
by
that.
deducting limitation period of 90 days and by excluding 716 days as per direction of the Apex Court's order dated 10/1/22 passed in the aforementioned case from the total number of days, i.e. 2702 days, the number of days of delay amounts to 1896.
My Lord.
My Lord, while filing, we already verified this one.
That's all right. You see, when someone has a doubt, there is no harm in getting it checked, isn't it? Now a report has been called, a report is submitted.
My Lord,
This
they make-
matter stands complete. As far as the number of days is concerned, it's sealed now.
They
The
make use
registry
of-
has given us 1896 and we'll proceed with 1896.
Yes, they-
Yes, now, what were the grounds of delay?
My Lord, we are not aware of the order. We came to know only on December 2022, where no notice was issued. Then without issuing,
Headship certificate?
yes, without making us in the party, headship certificate was issued.
When did you come to know?
On December 2022, and we applied because December is holiday. When court reopens, and we obtained copy on 23rd March 2022. Then we file
23rd March.
23rd March 2023.
From December to it took so much time.
But because normally we
When
applied,
did you apply?
we applied on Your Lordship on
Which
3rd.
paragraph? Application, which paragraph? First of all,
My Lord,
what is-
it is reflected in the documents itself, certified true copy here in all the documents itself. If you kindly see at page number 16.
Page number
16.
16.
Yes. Of my condonation of delay application.
What is this?
Annexure number 1.
Oh, this is their objection. 16.
Yes. There you'll see true copy with the seal of record keeper.
Yes. It says 23/3/23.
Yes, we obtained on this day.
No, but when did you apply?
We applied on, Your Lordship, on.
You see, Mr. Counsel, it is you are saying that you had the knowledge in December 2022.
22.
All right, December is a Christmas time. I understand.
Yes.
But thereafter, in January, February, and in March, you have got it.
Normally January.
So what has happened? January
January
maybe first
2nd week. Normally court opens on January
Very well.
2nd week.
I am with you till second week.
Yes.
What after second week of January?
We applied on, Your Lordship, we applied on this copy on second week of January.
Where are you?
I para 12 of my continuation application.
Para?
12. There was long delay during end of December and beginning of January 2022. And applicants further took steps second week of January. The court started functioning to obtain related documents in obtaining the order such and such.
And it was why that they took so much time in giving?
My Lord, because of that, because the order which we challenged, impugn order, was issued on 2016. It was on 6th October 2016. And after that, they filed appeal before district judge. They approached the wrong forum.
Yes, what is your objection?
My lord, in fact, my affidavit is not in the file here, so I need a day's time to prepare for this matter, my lord.
You
I
need
have to
what?
check from the file, my lord. My
Counsel, don't come up with all these excuses.
My
You
lord.
have filed filed the affidavit. Why will you not have a copy in your office? Yes, give him a copy, Mr. Pautu. Read from paragraph 4.
That by way of a preliminary objection, I beg to state that the number of days delay in filing the connected RFA number 8 of 2024 against the order dated 6/10/2016 passed by the Senior Civil Judge 5 Aizawl Judicial District Aizawl in airship application number so and so is 2611 days and not 1896 days as claimed by the applicants. In fact, the applicants...
Paragraph 4 ground is already clarified by
My
the
lord,
registrar.
my lord.
Now 5.
That the plain reading of the instant application reveals that the statements made in the instant application are different from the statements made by the applicants in CMA number 249 of 2023, that is the condonation of delay application filed along with RFA number 11 of 2023 before the lower court. In fact, the applicants have both failed to disclose facts stated by them in CMA number 249 of 2023 and have added facts to the statements made by them in CMA number 249 of 2023. This clearly shows that the applicants are guilty of non-disclosure of all facts which amounts
I
playing...
have not understood this.
This is, my lord, before filing this instant application, instant appeal, my lord, the applicants have approached the learned district judge by filing this RFA number 11 of 2023.
When did they file that? That
My
is
lord,
filed-
on April 3rd, we filed it on 2023.
That they have filed it after they have received the certified copies from the court in the month of
Yes,
March.
we received on
23.
23rd, we filed on March
Yes.
2nd, without any delay.
Next, para 6.
That with regard to the statements made in paras number 1 and 2 of the application, it may be pertinent to mention that after the respondent OP number 1 was declared as the legal heir of his deceased father Sheila Ribunga Sailaw late, in respect of the land and building covered by LSC number so and so located at Khatla Aizawl White order dated 6/10/2016 passed by the Senior Civil Judge 5 Aizawl in HC application number so and so, he had mutated the said LSC in his name after following all caudal formalities. However, the respondent OP number 1 had unfortunately passed away on 7/4/2022. Thereafter, the respondent OP number 2 had approached the competent court for issuance of heirship certificate in her favor with respect to LSC number so and so located at Khatla Aizawl, left behind by her deceased husband, that is the respondent OP number 1. The said application was registered as heirship certificate case number 1 of 2023 and subsequently the Honorable Court White order dated 16/1/2023 had issued heirship certificate bearing memo number so and so dated 16/1/2023 with respect to the aforesaid LSC in favor of the respondent OP number 2. In view of the following developments that had taken place, the instant application and the conducted appeal has become infructuous. That with regard to the statements made in paras number 3 to 8 of the application, I beg to state that the same being a matter of record need no comments except to the extent that the applicants were aware of the order dated 6/10/2016 issued by the learned Senior Civil Judge 5 Aizawl Judicial District Aizawl in airship certificate application number 1304 of 2016 and its connected airship certificate and had belatedly filed the appeal, that is RFA number 11 of 2023. That with regard to the statements made in paras number 9 and 10 of the application, I beg to state that a perusal of the application filed by the applicants demonstrates that the applicants have been negligent and careless in filing the appeal beyond the period of limitation. The delay of...
That's all.
My lord.
I think that is all. That is your main objection, isn't it?
Yes, my lord.
Anything else? See, with all due respect, you all are taking each and every word that they are saying and you're trying to find some lapses. But the delay, the condonation, parameters are well settled, isn't it?
My lord.
There can be lapses. That is why obviously a delay has occurred. Otherwise there will be no delay. there has to be some sort of lapses, isn't it?
My lord.
Now the question is whether that delay will be condoned or not condoned. How will that discretion, and it's a discretion of the court. How do the court exercise the discretion? This is a positive, it has to be a positive discretion, isn't it? Because if at this stage it is not condoned, it will close the matter forever. There has to be a balance. If you show that they have adopted dilatory tactics and deliberately they were sitting over, they were not being, it is that they have not been bona fide in pursuing, then of course this court will be with you.
My lord.
And length of delay is not the criteria. Undoubtedly in this matter there has been some delay, but the explanation is that they did not know. They came to know in December and January first week, we all know, Aizol, that is a festive time going on. Generally everything is closed. Second week of January, by which time generally the courts open, they have already applied. So how can you say that they are not being vigilant or bona fide? The moment the courts have opened in the second week of January, they have applied for the certified copy. This were given to them only in March 2023. And after that they have taken the steps. When is it filed at the end?
We filed on 4th March, but the previous council filed before district judge, because district judge only has pecuniary jurisdiction on 10 lakhs.
No, when?
On 4th March.
4th March.
Yes. Then that one appeal was disposed of, dismissed on 28 September.
4th March, but you said it was given to you on 23rd March.
23rd March, we received the copy, and 4th April.
That was filed before
District judge.
District judge.
And it was pending, and after that on 28/8, it was dismissed for want of jurisdiction.
28/8?
2023.
23. You had filed it before the district judge.
Yes, because district judge has only pecuniary jurisdiction
Want
of 10 lakhs.
jurisdiction.
Yes.
And then ultimately you filed it on?
Again, we file on.
You filed this appeal here?
Yes.
When?
Lordship, I have to see the order.
They filed it on, my lord, on 29 to 2024.
29
to 2024.
29?
To 2024.
Why from August?
Because, let me explain.
Yes.
Lordship, the previous council, that dismissal order was not communicated to the previous council. So it was he came to know only in the month of November. So then, and after that, we applied certified copy, because when
From the beginning you have been, there was delay, even after the then you file it before a court which does not have pecuniary jurisdiction.
Yes.
That got dismissed in August. Till February you have not filed.
Actually, order was not communicated, order was not given.
But you should have also gone and checked, since
Because, my
already
lord,
there has been so much delay in the case.
Because the thing is that the procedures we have, appeal to district court and high court is different. Appeal to district court, we don't need to obtain certified copy, folio paper, but here we need. Again, we have to apply folio paper of the dismissal, the order long time back in 2016. It is very long case report, and we obtain only that one on February 2000.
Which paragraph you have mentioned about the subsequent thing?
My lord, it from ground number 16. My lord, let me just explain very shortly, briefly.
One second. In November 23, you were informed.
Yes.
And then the case record file was lost.
Yes. Even the previous council also had written that letter also.
There has been explanation, Mr. Kliang Thing Liama, right?
My lord.
It appears that sufficient explanation has been given.
My lord, if I may be given only a day's time, my lord, I will come prepared
How
tomorrow.
can
my
you
lord.
improve the
Because, my lord,
matter over a
the-
day and it's a condonation.
I
Mr.
understand that,
Counsel,
my lord, but
please,
I'm not
you are
well versed
also
with the.
often officer of the court. These are condonation application. If it had been some other application, I would have certainly, if it would have been the RFA,
My lord.
I would have certainly given you that time.
My
All
lord.
right, I'm giving you 5 minutes time. Think over. I'm coming back in 5 minutes. If required, I shall accommodate, but you see, it is only about an objection, right?
Understand.
My lord,
And
I have their own.
you cannot change the grounds. The grounds
Understand.
you have seen. It appears that there are sufficient grounds. Only
My
thing,
lord.
yes.
I have their judgment. You condone 1,900 and more than
No,
that.
no,
I
that
have
cannot
the
be a
copy.
that cannot be a precedent.
Actually,
The law is the precedent which will be applied to your case. Just because in some case I have condoned 1,000 doesn't mean I will condone here. You have to satisfy the court that you have sufficient reason. That is the main thing.
My lord, if I may, my lord.
Yes, Mr. Malhotra.
Your Worship.
Your case is become the precedent now.
Yes.
I think that case that you're referring is a case where Mr. Malhotra
Yes,
was
exactly,
in
my
the
lord.
other side, right?
Yes.
Your Worship, I just have one submission to make. If your Lordship will allow me to read from paras 17 to 20 of the application filed by them for consideration of delay.
Yes, please.
I'll read from para 17,
Yes.
page 11. That the applicants have to search for new advocate since the said counsel did not appear in the High Court and started approaching this present counsel in the middle of November 2023. As the previous counsel lost the case record / file of the applicants and did not receive a copy of disposal order of RFA number 11 of 2023, the new counsel on 15/11/2023 immediately applied copies of documents including disposal orders in RFA 11 of 2023 to the district judge in the prescribed form, which was received and acknowledged by the concerned officer at the body of the application. Para 18. It is apt to state here that in the meantime, after application of copies of documents, including disposal orders in RFA 11 of 2023 on 15/11/2023, the applicants, through their counsel, applied for certified true copy on folio of the impugned order dated 6/10/2016 on 21/11/23, and the same was obtained on the next day, that is 22/11/23. However, copies of documents, including disposal orders in RFA 11 of 2023, could not be furnished to the applicants, without which no appeal could be preferred, as the disposal order and documents submitted in the appeal were to be relied upon by the
See,
applicants.
Mr. Malhotra, there are so much of detailed explanation.
So, Your Worship, what I'm trying to say, Your Worship, is that here they say that the documents regarding RFA 15 of 2023 were lost by the previous council, and they had to apply for certified copies from the lower court. But then, if I take Your Lordship to the Annexure 3,
Page?
page 31.
Yes.
If Your Lordship will see page 31, Annexure 3, this is a copy of the RFA filed by them in the district court,
Which was dismissed.
which was dismissed. This is a copy of the RFA which was filed by them in the district court. In the application for condonation, they say that the file was misplaced by the council, and because of that, they had to apply for certified copies. But this is not a copy, this is not a certified copy.
Let me explain.
Let me finish. This is not a certified copy. This is a copy which was retained by them. There's nothing mentioned here.
So you are trying to say that they have not come with clean
They have
hands?
concocted this story.
That means they have not been before this court with clean hands, not
Yes.
bona fide.
Yes.
And that is why this court should not exercise the discretion in their favor.
Yes.
Is this what you are trying to...
That is what this is a concocted story that the file was misplaced by their lawyer, because of which they had to apply for certified copies of all the documents as well as the...
Because this Annexure 3, this Annexure 3 is a document from where are you showing? From the
Condonation of delay application.
this is annexed to the delay application,
Yes.
right? By them.
By them.
And it's not a certified copy.
It is not a... Annexure 4 also, if Your Lordship will see. Annexure 4, page 40. This is a...
Annexure 4 is a photocopy of a certified copy.
No, this is... Annexure 4 is a Xerox copy of the condonation of delay application filed by them. This is not a certified copy issued by the lower
Before the
court.
district judge.
Yes, before the district judge.
What is this date? In the site, there are two dates. One is 6/4/23. What does that date mean?
6/4/23 is the date by which it was received by the concerned court. It was endorsed by the district judge on 3rd of April 2023, which is on the top left-hand corner. Just below that, 6/4/23 is the date it was received by the concerned court, additional district and session judge. So, and again, Annexure 5.
And the story that they are saying is that in sometime in November, they have again reconstructed these documents.
Page
Correct.
Page
That
60.
that is the
Yes.
story that they're bringing.
Annexure 9, Your Worship.
Page?
Annexure 9, page 60. If Your Lordship will see, page 60, annexure 9.
First, you have shown page 31.
Yes.
Next was page,
Page 40, annexure 4.
and then now
And then your Lordship may kindly see the annexure 5 also, page 46.
page 40.
6. Again, these are all Xerox copies. These documents were very well within their possession. Page 46, this is the written objection. And again, page 53.
Yes.
Page 53, annexure 6 is the copy of the order dismissing the condonation of delay application.
Yes.
CMA 249 of 2023. Then annexure 7, page 56 is the copy of the order dismissing the RFA 11 of 2020.
Yes.
So all these documents were in their possession.
And which is the paragraph where they have said that these documents were misplaced?
Para 17,
Pass.
at page 11.
Yes, I have it.
Your Lordship will kindly, para 90 is also very relevant.
Para?
90.
Yes.
During beginning of December 2023, the applicants through their counsels kept inquiring about documents sought in respect of RFA 11 of 2023 and requested the concerned clerks to expedite the search as they wanted to file appeal before court winter vacations. But copies could not be furnished and winter vacations started from middle of December 2023 and courts started functioning properly from 16/1/2024. The applicants were given copies of documents including disposal orders dated 28/8/2023 in RFA 11 of 23 and its connected CMA number 249 of 20.
What document is there to show that these documents were given in the second week of February 2024?
Nothing
My
has
lord,
been produced by.
my lord, there are two types of document, I'll tell you.
No, I am asking a very straightforward question. Please give me an answer. No explanation is required because your stand is that these documents have been lost by the previous council.
Yes.
Therefore, the new council had to apply, and there is an averment on oath that these documents have been given to the council in the second week of February 2024.
Yes.
Now, what is the document from which you can show that these documents, if it's a certified copy, the date will be mentioned?
Yes.
Yes, my lord.
So please show me that particular document. Nothing more, nothing less.
Folio, the documents on folio.
Where?
At the very first page.
Page?
It, actually, we normally enclose at the very beginning of the appeal. The original we have to enclose. That one.
No,
Because
that
we
is-
need to have only one folio.
Mr. Counsel, that folio which you had shown me is only in respect of the, I think, the order.
Yes.
What about the other documents?
And I'll explain again.
Where is that page?
At very beginning at the folio. Read up. I think in appeal, main appeal. It normally we have to enclose.
It's not there here. Main appeal. There. This shows 21/11/23 application was made
Yes.
and it was delivered on 22/11/2023.
Yes.
But
I said that also it was delivered on the next day.
That's only the certified copy.
This is certified on folio.
Mr. Counsel, this is only the certified copy of the order dated 6/10/2016.
Yes.
What about the others?
Yes, this is the order of the first court.
Counsel, are you following what
I am following. Another is that since he is not having, clients were not having any documents, we have to apply again to district judge.
Where
There-
are those?
Yes, there
Where is the copy showing that you have received them on the February?
it is not, because we just they handed over to us. And it must definitely, it will be written certified copy.
Sorry, that explanation is not good enough because this one shows you got it in November 2023. And this court, the pointed question that this court put to you
Yes.
is paragraph 19, where you have said the applicants were given copies of documents including disposal order dated 28/8/23 in RFA so and connected so in the second week of February 24.
My lord,
Which is the document to support this para?
my lord, normally the process we have is that folio, it is written. Here,
Where is it written? That's what I'm asking.
yes, it is written. I just have point out that it on the next day we are given folio. Folio in tabular form, it is normally
You are
reflected.
not clarifying the doubt of the court.
And the second one, I will explain. The second
No,
one.
you see, if you have obtained it, there must be some proof of it. If you don't have it in the papers here, you may have it
My
at
lord,
your office
If,
or your file, Mr. Pauto.
My lord.
The file.
my lord, I'll explain. Even it is there, in normally in the court, they'll record. Then at the times of written objection, they can make it. My lord, we applied, we asked them, and normally they
See,
had,
when you make any application in any
Yes.
court, there is a form.
yes, a form is
Correct?
there.
So they will note down. And then when they hand it over also, there will be a date.
No, my lord, they don't make it the date.
Mr. Malhotra, here date are not mentioned.
If they have it, they can prove it. They can show it our receipt.
Your Worship, it is their statement that they received.
Yes, Mr. Malhotra, this is a doubt. That's why I'm asking you.
Yes.
Here, as far as the practice of the district courts are concerned, when any copies of the pleadings are sought for,
Yes.
at the time of handing over, date is not mentioned.
It is given, Your Worship. It is very much given. Like for this, for example, page 28.
This is folio.
Page 28.
Yes, yes. Certified to be true copy.
Yes, this is the order which was passed in 2016.
This is given on 22nd 11.
Yes, they applied on 24th, so it is always mentioned the date of.
In folio, it is always mentioned.
So where is the February date?
Yes, in folio and February.
Where?
My lord, that I submitted, there is no record. If
How
it is
can
there-
it be?
If it
If
is,
November date is there, what about for February?
my lord, only on folio, the form is there. Signature, we have to put everything. But certified copy.
You are not inspiring confidence, Mr. Counsel.
My lord,
I'm trying to, you see, I'm being very liberal as far as condonations are concerned. But you have to make out a case.
Page 60. Your Worship.
If you show me a document showing that in February it was given to you, very well. It is mentioned in your para, but there is no, the documents which Mr. Malhotra has shown from page 31, 40, 46, 53, 51, and appears to be all Xerox copies. And these are copies obviously were available with you.
my lord,
Your copies.
my lord,
Now you are trying to make out a case that no, these all copies were with the lawyer lost it and we reapplied it and we got it in the second week of February, correct? This is your stand? That
yes,
you,
my lord, there is application. If you kindly see the application, I'll take you to
Yes,
application
yes,
again.
Yes.
Page 60 is the application.
Page?
60. Annexure 9.
60.
Yes. Date
Here-
of application November.
Yes, Lordship, the certified true copy of all the documents, here it was received
Where?
at the corner on 15/11/2023.
Yes, but you said no, February.
15/11/23 is the date of application, Your Worship.
Correct. You come down, date of application.
And on, my lord, one thing-
Otherwise, it could be then on November only you got it.
My
Same
lord.
day you applied, same day you got it.
let me just explain the first continuation of delay. Because in the first continuation of delay, before the district judge, their contention is that they came to know, they applied on 23rd, second week of February, they received on 23rd March. And it was there, here with the round seal, certified copy, date were mentioned
Where?
in all the documents. In the judgment
But,
itself,
let's go one by one, otherwise you're confusing the court. If you want an order in your favor, you must clarify the doubts of
Yes,
the court.
Lordship,
How
I'll
will
take-
the court author a judgment if the facts are not cleared?
I'll take you to Lordship again to
See, come to 60.
Annexure 1.
First come to page 60.
Yes.
Are you at page 60?
Yes, I'm here.
The last column, can you see date of, first you see documents applied for.
Before that, Your Lordship.
No, you first.
Yes.
Please answer the query, first clarify the queries of the
Okay.
court.
Your Lordship,
Kindly see what are the documents that you had applied for. Please see.
certified true copy of all documents, RFA petition.
Condonation.
RFA is before the district judge.
Please see condonation of delay, written objection,
Yes.
disposal order.
Yes.
So everything, right?
Yes. Yes.
And then you see the date of application.
1511.
Now, when did these documents were given to you? Because in paragraph 19, you say February 24. The applicants were given copies of documents including disposal order so and so in the second week of February 24.
Yes, that's exactly true.
Now, how do you show it? Because this is only application that you had made in the month of November 23.
Yes.
When were these documents given to you? How can you show?
My Lord, the
from where?
process we have is here. There are two types of document we normally apply. One is certified copy on folio. In that one, we need date, everything. They'll sign by the registry from the lower court. And also that is in page number 1. It is very clear. We applied on 21st. We receive on the next day. That is folio.
That is for certified.
Yeah, certified folio.
Okay.
And all these things, they used to acknowledge or receipt everything. But true copy, for true copy, they never maintained a record. We kept, I make a statement
Mr.
also.
Counsel, now come back to page 60 and see what was the application that you made. Please see on the top.
Yes.
Which column you had tick marked, true copy or certified true copy?
My Lord, though we...
No. Please, you see, Mr. Counsel, you are before a court which is exercising a discretionary power. You have to inspire confidence. Otherwise, it appears that you have concocted a story.
Okay,
You have to clarify.
Your Lordship.
You just now, you had submitted that there are two types of applications that you make. One is a true copy and one is a certified true
Yes.
copy. And it is your submission, which is been recorded in live streaming,
Yes.
that in case of a certified true copy, a folio is maintained.
Yes.
Correct?
Yes.
Now page 60 appears that your application is tick marked for certified true copy.
My Lord,
Yes or no?
here, the
Yes or
application,
no?
yes, Your Lordship,
Then,
yes.
Then
And applied, but we are given folio paper on 21st. But this order we are given on February, and in wherein there is no record that we received prior to February. My Lord, even before also I submitted that when they applied on February, and also that time there is only true copy.
but your document is not supporting you.
But Your Lordship, that folio paper, it is very clear that my statement, as per my statement,
Which folio paper?
this one, page number, at the very first one, certified copy.
That is the court's order.
Yes.
That is different.
Yes.
That is the certified copy of the impugned order.
2016 order.
Yes, that is different. We are talking about page 60.
My Lord, we
Paragraph 19 is related to page 60.
my
Is
Lord,
it
we
not?
can look for the record if they have registry maintained the date when we are given copies. We'll look for it.
When can we have it? Tomorrow? Day after tomorrow?
After,
Day after tomorrow.
because normally we apply, there is a maintenance.
Marshal, please write it down like this. Please record the presence of both sides and then say that Mr. Malhotra, learned counsel for the respondent, draws the attention of the court that the documents annexed as at page 31, 40, 46, 53 and 51 belies the stand of the applicant as regards their knowledge, as regards their stand made in paragraph 17 and 19 of the interlocutory application, to the effect that the documents of the case records of the
RFA
RFA
11 of 2020.
11 of 2023 and connected
Condonation of delay
miscellaneous applications were misplaced by the earlier council, and after engaging a new council, the same were obtained only in the second week of February 2024. Stop. It appears from Annexure 9 enclosed to the aforesaid interlocutory application that the applicant on 15/11/2023 applied for the certified true copy of all documents, in connection with the said RFA, including condonation of delay and written objections and the disposal order, etc. However, no documents as on which date the said documents were made available to the applicant is enclosed in the interlocutory application. Mr. So-and-so, learned counsel for the applicant, though submitted that in case of applications made in respect of true copy, no folio. What did you say?
No folio paper.
No folio paper.
And describing the date when it was delivered.
Mentioning the date of delivery is attached to the documents. Stop. However, in the given case, this court observes that at the top column of the document enclosed as Annexure 9, the applicant has marked for application for certified true copy. Be it as it may, as Mr. So-and-so, learned counsel for the applicant, prays for 2 days to obtain, to take instruction as regards if there is any document showing the date of delivery of the aforesaid documents.
My submission is that there never be documents report. They just hand it over to us.
I have said it. But this submission you have made is in respect of true copy.
Yes. Because
isn't it?
Certified
It is
copy
mentioned.
is not yet delivered till today.
Very well. Very well. You see, I have appreciated your submission, but in this form, you have tick mark for certified true copy, not for true copy.
Certified true copy is not yet delivered till today also.
Anyway, so that means you already had the Xerox copies?
Where did these come up from?
That means, you see, you have to be careful of what you say, Mr. Counsel.
Yes.
Because then it appears that all these documents which are the Xerox copies was all along available with you. And you are trying to only make out a case. Please be careful of what you say. Okay? Accordingly, prayer is allowed. List on Wednesday, on such and such date.
If these documents were issued on February, they should have been signed by the concerned officer, issued on, and the date should have been given.
Something has to be there, Mr. Malhotra.
Yes.
Something has to be there, and it is the case of that is why I recorded the submission, because it is the submission of the applicant that in case of certified true copy there will be some record, but in case of true copy there will be no
My
record.
lord, one thing is that
that is your submission.
No,
and
normally
I find from page
it depends
60,
on the pass card, those who Xerox. My lord, even page number 19, here notarial copies, everything is there.
All right.
This is from the court, it's very clearly reflected.
This is that content. All right,
Yes,
Wednesday.
much appreciated.
Part 2, item number 2.
You may take your seat. Just 2 pages, just let me know. Number 1, at which page will I get the evidence of the plaintiff, Mr. Lalaram Anga? At which page?
My lord. Lordship, evidence starts from page
Yes,
41.
Mr. Miller, page
41.
41?
Yes.
41.
41.
And the plaint?
Plaint starts from page 1, my lord.
Okay, all right. But pertinent at this juncture to refer to Order 9, Rule 7 of CPC, which provides as hereunder. Order 6, Order 9, Rule 6, huh? You quote unquote. It appears that, not it appears, apparent that when the defendants does not appear despite the summons being duly served on the date for hearing, comma, the trial court is entitled to make an order that the suit be heard ex parte. Stop. As stated above, in this case, the suit proceeded ex parte for the non-appearance of the defendants despite of receipt of summons issued repeatedly.
My lord, I would just like to intervene. There is no receipt of summons in any
No,
part of this.
but in the order of the court it is mentioned. It is mentioned.
Other than that, there's nothing else.
You could have filed a cross appeal, Mr. Miller. So, since there is a no cross appeal, I will take with what is mentioned in the order. It is mentioned. Anyway, for your satisfaction,
Page 50.
I will read it. Page
50, my lord.
50.
Yes, 50. Para number 2.
Yes, notices were sent to the defendants on several occasions and were duly served upon them. However, the defendants did not appear in the court nor are represented by any counsel. Hence, the case proceeded ex parte on 22/11/21. Put the date, huh? Proceeded ex parte on 22/11/2021. Paragraph 2 of the impugned judgment is reproduced hereunder for ready reference. Quote unquote. Page 50, A to A. Order 8, Rule 10, right? Yes. Order 8, Rule 10 of CPC, which provides the procedure when party fails to present written statement called for by court is also reproduced hereunder for ready reference. Quote unquote. Okay. Apparent that non-filing of written statement, comma, the trial court is entitled to pronounce judgment against the defendant or make such order in relation to the suit as it thinks fit, and on the pronouncement of such judgment a decree shall be drawn up. Stop. In the present case, in order for issues to be satisfied and established by the plaintiff, in order to be entitled for the declaration sought in the suit. Stop. It appears that the trial court has returned a finding in favor of the plaintiff as regards the first three issues so formulated, as regards the plaintiff stroke appellant's right, title to the subject land, and the infringement infringement thereof by the defendant in denying the plaintiff title to such land, and the declaration that the plaintiff is entitled to such legal character or right in respect of the subject land. Stop. Paragraph 8 of the trial court's judgment is reproduced hereunder for ready reference. Apparent from this is C2, page 52. Apparent from the above that the trial court has clearly declared the plaintiff as the declared the plaintiff entitled to the subject land by declaring the plaintiff the rightful title holder. It is further apparent from reading of the plaint especially paragraph Roman 4, 5, 6, 7 of paragraph 3, that the defendants have forcefully occupied the subject land of the plaintiff appellant in order to store by establishing camps and storing machines, machinery tools, etc. The plaintiff appellant cannot be deprived from his land without any established procedure of law. The apex court in the case of Calcutta Municipal Corporation and another versus Bimal Kumar Shah have stated, have held that the right to property is not only a constitutional right but a basic human right. Paragraph 24, 25, 27, 28, 29 of the aforesaid judgment is reproduced hereunder for ready reference. In paragraph 30.5, the apex court, after highlighting that there are 7 principles which has to be followed while the state acquires a land are: 1, right to notice; number 2, right to be heard; number 3, the right to a reasoned decision; number 4, the duty to acquire only for public purpose; number 5, the right of restitution or fair compensation; then the right to an efficient and expeditious process; and last, the right of conclusion. Thus, deprivation or extinguishment of that right, thus a person's right to hold and enjoy property is an integral part to the constitutional right under Article 300A. Deprivation or extinguishment of that right is permissible only upon restitution, but it in the form of monetary compensation, rehabilitation, or other similar means. Compensation has, the apex court has further held in the aforesaid decision that the compensation has always been considered to be an integral part of the process of acquisition. Paragraph 30.5 of the aforesaid judgment is also reproduced hereunder for ready reference, quote unquote, page 23 of that judgment. In the instant case, it appears that the state government had acquired land by notification dated 28/2008, private lands, private lands, under Section 4 of the Land Acquisition Act 1894 for the construction of a new 2-lane highway from NH 54 near Longklai to Indo-Myanmar border in Mizoram to support Kaladan Multi-Modal Transport Project Phase A under SRDP-NE, and subsequently by declaration on 12/4/2010 under Section 6 of the said Act, and subsequently declaration was made. Okay. It further appears that thereafter on 24/2010, the Deputy Commissioner Longklai District issued notice to persons interested under Section 9 of the said Act stating the government's intention to take possession of the said land and that claims to compensation for all interest in such land may be made to the concerned authority. Stop. It further appears that pursuant to the state government inviting tender, defendant numbers 1 and 2 stroke respondents were appointed to execute the said work in favor the said work. Stop. It appears that though the subject land of the applicants were not acquired by the state government, however, the defendants number 1 and 2 stroke respondents forcefully and illegally occupied 1400 square meters of the plaintiff's land bearing LSC number 20 of 2011 of 27/7/2011 out of an area covering 50,000 square meters, and 4 houses including 1 reservoir were also constructed thereon by the defendant numbers 1 and 2 stroke respondents without prior permission and consent of the plaintiffs. It appears that the trial court has clearly held that the plaintiff is entitled for the declaration of title in favor of the said land occupied by the defendant numbers 1 and 2 stroke respondent. Stop. Since there is no cross appeal against the aforesaid verdict of the trial court, the entitlement title of the plaintiff stroke appellant as regards the land forcefully occupied by the defendant numbers 1 and 2 stroke respondents stands confirmed. the logical. Therefore, it is apparent that the plaintiff appellant has been deprived from enjoying his own land without the same being acquired by the state government. It further appears that no compensation whatsoever has been given to the plaintiff appellant either by the defendant numbers 1 and 2 / the contractors, nor by the state government for these contractors / defendant numbers 1 and 2 forcefully occupying the subject land of the plaintiff appellant. The said occupation of the defendant numbers 1 and 2 is absolutely illegal and amounts to total violation of the constitutional and basic human rights of the plaintiff appellant. Thus, following by the ratio of the apex court in the decision of Kolkata Municipal Corporation Supra, the plaintiff appellant is entitled for compensation thereof. The trial court's order, to the extent that where is that order?
Page.
The last portion. To
Page
the
53.
extent that the plaintiff did not produce any documentary proof to reveal that there is rental agreement between the parties and that there is no basis for computing the amount claimed by the plaintiff and that there is no relationship of landlord and tenant between the parties between the parties for the plaintiff to claim for rental compensation, and therefore the plaintiff failed to fulfill the last condition to enable an order of declaration and accordingly has not established his case with any oral or documentary evidence and therefore dismissed the suit. In the considered opinion of this court is totally erroneous. Stop. Apart from Order 8, Rule 10, Rule 5 of Order 8, specifically Sub-Rule 2, is of relevance in the matter, which is reproduced hereunder for ready reference. Reading of the aforesaid provision appears that where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of the facts contained in the plaint. However, the court may in its discretion require any such fact to be proved. Stop. In the present case, the plaintiff appellant in paragraph 11, 12 and 15 have clearly deposed, have clearly averred that, and also 9, first 9, has clearly averred that the plaintiff has been deprived, that due to the deprivation of the plaintiff appellant to use and utilize the subject land, which is his primary source of income, he has been unreasonably and immensely suffering till date. It further appears that the plaintiff appellant has assessed a compensation at a rate of rupees 50,000 only per month, and the arrears amounting to rupees 52 lakhs only with an interest at a rate of 6% per annum, accruing the illegal and forceful occupancy of the plaintiff's land for a period of January 2012, August 2020, within a period of 30 days from the date of issuance of a legal notice dated 11/9/2020, stands unrebutted and therefore admitted. Thus, the basis for the compensation is available in the plaint and which stands admitted. Further, where is the evidence? 41.
Yes, madam. 41.
Pertinent also that the plaintiff has deposed as hereunder during his examination in chief. Page 42. Page 42 to page 44, D to D. Only one evidence.
2, my lord.
2.
PW2 is at page.
That may not be relevant.
Yes.
So, thus, the basis for compensation is there both in the pleading and the evidence of the plaintiff appellant. Right. I will dictate the ending later on in the chamber, but otherwise disposed of.
Highly obliged.
So it disposed of.
Part 2, item number 2.